It's 1 minute past the 11. So good morning and welcome all to our quarterly legal update brought to you by Fixflo. My name's Will Arrowsmith. I'm head of sales here, and today we will be discussing what to expect ahead of the next election in terms of the UK lettings market. As always, I'm joined by the ineffable David Smith. David, good morning. How are you?
I'm feeling very ineffable, thank you.
Great stuff. Yeah, it's a good way to be feeling this morning. It's a sunny morning, so there we go. Great stuff, guys. Just in terms of what we're going to be cover and to set your expectations today. So kind of 4 key points, if you like. We'll focus first up on what will happen should the Conservatives stay in power past July the 4th. Of course, we've spoken a lot about that in the previous years. Perhaps a continuation of that, whether that will be the case or not, we shall see. But talk a bit about that part of the spectrum. Second piece, we'll jump onto the Labour manifesto and jump into everything in terms of the UK rental market, what it would mean for us and the broader housing market as well. Also, maybe the odd reference to the manifestos of the other parties that have also been released in recent weeks. Third thing, as we always do, jump into a couple of legal updates, some that David's working on, some that he isn't, but just that he's got as points of reference for us to be aware of in the industry. And then the final part, as we like to do, to leave kind of a section for Q&A. We have, of course, the Q&A button, which will jump on and show you how to work, but do send them our way as we go through. But quickly, before we show you how that works, as always, a disclaimer. So all content presented in this webinar is intended for general information purposes only and should not be considered as legal advice or official guidance. Other final piece of housekeeping before we get on with it is the question bar. Hopefully you're familiar with this if you've attended our legal update webinars in the past, or any Fixflo webinar that is actually. We have the question box on the bottom of Zoom and just showing you how to ask those as we go through. Please do send them our way and our marketing team will kind of siphon them through to David and I as we go through. Perfect stuff. So David, to kick us off, of course, as Parliament was dissolved for the pre-election, the Renters Reform Bill was kind of thrown off the table to an extent. But in terms of the Conservative manifesto, what we've been speaking about for years now, what would that kind of entail for us in the future should the Conservatives stay in power?
Yeah, I mean, the Renters Reform Bill very nearly made it. There was a long discussion between the parties, I'm given to understand, until fairly late at night, and the Leasehold and Freehold Reform Bill survived that discussion, and the Renters Reform Bill did not survive that discussion. And as I understand it, there was a bit of basically it was to do with what specific amendments, and mostly the third reading amendments that had been made, whether or not those would carry through, and it wasn't agreed, and so away it goes. The Conservative Party and their manifesto, and obviously we focused on the Conservative and Labour manifestos. I was going to say we focused on the manifestos of the 2 main parties, but depending on who you believe, we may have focused on one main party and some also rans. It just depends on how you choose to view the polls. I should perhaps be talking about the Reform manifesto because apparently they will be the official opposition. So maybe we should ignore the Conservative manifesto and talk about the Reform manifesto or the Liberal Democrat manifesto, who may also be in there as the official opposition. You could just never tell at the moment. But assuming it's for a moment that it's either a Conservative or Labour situation, the Conservative manifesto has put in directly that it will bring back the Renters Reform Bill. Now, I was a bit surprised when I saw this, and to be honest, I don't really believe them, because I think you need to look at the whole picture. If the Conservative Party were to come back as the next government, which I have to say I think is a slender possibility at this stage, but you never can tell. Stranger things have happened. It would, I think that they wouldn't have much majority, it'd be pretty slim. The way the polls are looking, the party would certainly have shifted more to the right
Mhm.
Michael Gove, who was a major architect and a major cheerleader for the Renters Reform Bill, is not standing, so he will not be back. Um, so I'd be quite surprised, actually, if a weakened Conservative government had much appetite for the Renters Reform Bill, given the significant amount of backbench and particularly right-wing backbench distaste for it as being unconservative, uh,
Mhm.
and the fact that their peers in the House of Lords weren't exactly mustard keen on it either. So and although Labour were clearly keen on it, you don't really want to be a government that gets your bills through because the opposition let you. That's not normally the way we do government in the UK, and it doesn't tend to lead to long-lasting governments, frankly. So despite it being in the Conservative manifesto, I can't see it as being something that they would be very likely to pursue in practice. And
Okay.
I think they would focus their energy much more on further tweaks to the planning system. I was going to say planning reform, but no, not really. Come on. And further talk about house building, as I think I mentioned in one of my LinkedIn posts recently. I was wryly amused by the sort of one-upmanship of home building targets that appeared from various parties. And in one of the early head-to-heads between Sunak and Starmer, Sunak said, "We've built 1 million houses in this parliament," and Keir Starmer immediately says an aside, "We'll build 1.5 million." And by the time it got to the Conservative manifesto, they'd got it to 1.6 million, and I saw the Lib Dems trumped them both with 1.9 million. And I was just wondering if another totally inflated, ridiculous number would appear from somebody else. But so far, I think 1.9 million is your high watermark.
Oh, there's still time. There's still time. So there we go.
Well, I'm always hopeful that obviously the Reform Manifesto is merely a draft, so you never know. It might go out there for 2 million to
Something beginning with a
trump
T.
everyone.
There we go.
But I mean, these numbers are just clearly made up. I'm so sorry to say. I don't want to dump on any particular political party, but I think the numbers are just made up by all of them. I don't see any basis on which any of them can purport to build any particular number of homes. I mean, the Conservative 1 million number was struggled. They've really struggled to meet it. Um, you've also got to bear in mind that just because you build a home, it may not be the right place, and there's this, and it may not be the right type. If you build lots and lots and lots of one-bed flats, but what actually people really want is three-bed houses or two-bed flats, which is where some of the biggest shortages are on the market, then it doesn't really matter how many one-bed flats you've built. If no one really wants them, they wasn't a terribly useful piece of building. So the difficulty also is just is multifaceted. One, you've got to provide the homes in the first place, but then they've got to be of suitable quality, then they need to be in the right place, and then they need to be the right type.
Hmm.
Um, and all of these numbers don't really address those issues. It doesn't actually matter how many houses people build, it's whether they build the right houses in the right place for the right people at the right price.
Of course. And I guess interesting point about the Renters Reform Bill there, and kind of you mentioned the appetite to bring it back. Do you think I guess the kind of core pillars of it will remain, be that abolishing Section 21, the fixed term tenancy piece in there, which was got lots of people talking. Do you think those kind of pillars could remain despite it being in a different guise potentially?
If it was a Conservative government, yeah, I think they'd probably just bring back pretty much where they'd got to at third reading and roll on with it.
Hmm.
Um, I mean, it's possible they would re-alter it, but there's not much point in doing it if you're not going to get rid of Section 21 fixed term tenancies. And if you're not going to get rid of those things, then you may as well not really bother. I mean, yeah, you're quite right. I could easily see a Conservative government saying, "I want to reform renting, bring in a renters reform bill without any substantive reform at all," and fiddling in other places. And there was lots of other fiddling in the renters reform bill in terms of national landlord registers and ombudsman and things like that. And you could bring all that stuff in, but it's not really reforming renting in that situation now, is it?
No. And I think
Perhaps we should talk about a more likely manifesto and a more likely party of government. How about that?
you're saying it, not me. So there we go.
Well, I'm not hanging my hat. I said more likely. I think that's a fair assessment. I haven't put any money on it. I'm not going to the bookies and gambling on it or anything. I didn't bet
Uh,
on the date of the election either.
I'm
Um,
glad.
I'm skipping the slightly snippy comments to Conservative support being withdrawn this morning for people who did in fact bet on the election day, which has just happened the last half hour.
Oh, there you go. I missed that one.
Um, well, you were busy getting coffee, you see.
Oh, there we go. See, taking my secrets, putting them out in the world. So there we go. But yeah, no, moving on to the Labour side of things. Of course, I guess they've been under the phrase Keir Starmer said a lot about making the rental sector fairer. I guess the kind of what are the kind of key points involved in that from a legislative standpoint that they've got
Right. Well,
across.
there's been a number of different things said in different places, and they're not all being hugely accurately reported. And I saw, for example, lots of people bringing up something Angela Rayner said on LBC months and months ago about reforming courts. So I think you need to be quite careful what's being said and where. In the manifesto, there are two specific promises. The first, and one of them is not really a promise in the true sense of the word, because the first is to get rid of Section 21 immediately.
Mhm.
Um, well, let's break that down for a minute. You can't actually do that. I mean, it's not possible for the Labour Party to come in and on day one say no more Section 21s from today. What you could do is pass an Act of Parliament. Obviously, then it's a version of the Renters Reform Bill,
Mhm.
which will get rid of Section 21. And in principle, you could backdate that Act of Parliament such that Section 21s from the past were no longer effective. But that would be an enormously unusual and surprising thing to do. And I think I'd be surprised if the Labour government was prepared to be quite so extreme and radical.
You bring that up because you've heard it hinted at, or is that just a point to
No,
say
I've
that?
I've not heard anyone hinting at that because I think I merely point out that it's possible, and the Scots government did do something not dissimilar in relation to agricultural notices to quit, but in fact were forced to withdraw it because the Supreme Court ultimately found it was unlawful and irrational. So um, that wouldn't really happen to a Westminster Parliament because the Supreme Court has more power over Scottish government acts and so on. But it's it would be very difficult to put through a piece of legislation that worked retrospectively in that manner without very, very good reasons. So I think what they really mean is that they will start the process of passing legislation quite quickly. Um,
Mhm.
they've also indicated that they will not be having much of a summer recess and that MPs will not get their traditional summer holiday. So they will have to to cut that back. They will curtail it, but there are still time things that they have to deal with. They have to have a recess for conference in October. You can't not have party conferences because for political parties, party conferences are where most of their money comes from. And immediately after an election, they're pretty short of money. And so even if the Labour Party wanted to get on with it and keep churning through Parliament, the reality is they need a party conference to refill their coffers after spending lots and lots of money making sure people voted for them. Um, so there's only a limited amount of time actually available between July and conference recess, and you're going to have some kind of summer recess. You can't not have summer recess because MPs who have just been elected need to spend time in their constituencies listening to their constituents, and that's their job. You can't be in Westminster all the time. It just won't work. So there has to be some summer recess, even if it's curtailed. So that leaves a couple of possibilities, both of which I have heard being canvassed in different ways. One is you do a mini bill that just basically gets rid of Section 21 and makes some amendments to Section 8, probably along the lines of that which you have already seen. Although that said, I'm not at all convinced that the Labour Party will be interested in a student ground for possession. There isn't one in Wales. I'm not at all convinced that they will replicate that in England. But that's up for discussion.
Just while
The
we're
other
here,
option, say again, sorry.
yeah, while we're here, just those other that I know we've recounted them many a time, but just those, just to flick through the kind of Section 8 bolstering points, the kind of key
Yeah, I mean,
main.
loads and loads of them are actually entirely to do with social housing.
Mhm.
The remaining ones are sale. So a landlord wishes to sell. I think that would probably keep in there. An amendment to antisocial behaviour. I don't think the Labour Party will do that. I think it'll stay as it is. And then also a ground for possession where there's more than 2 months arrears 3 times in 3 years. I don't think the Labour Party will retain that ground either, but I don't think it was very useful anyway. It was just far too complicated and far too arcane to interest most people in practice. And then getting rid of loads of the sort of prior notice stuff. A lot of that went away.
Mhm.
Where I think it will get more interesting is for example, all the stuff about not having gas safeties and not having HMO licenses and all of that stuff had gone away, and the only thing that you had to do was show your deposit was protected. I don't know if the Labour Party will take a different view on those things, and I think they'll be under some pressure to say you can't have repossession without gas safeties and things. But I think they'd have to be quite careful about that. You can't realistically deprive someone of their property for a technical reason for an extended period. If someone's in rent arrears, for example, you can't place a position, landlords in position where they can't get their house back at all.
Mhm.
And you'd find that your legislation would be ruled unlawful. So you have to be quite cautious. And I don't think the Labour Party are going to want to put landlords in a position where the tenants can't pay rent and they can't get it back reasonably easily. That's not something that they've ever suggested they would do. And indeed, Angela Rayner's comments from LBC a few months ago made clear that they felt that landlords should be able to get their properties back reasonably expeditiously in the right circumstances. So I don't think that they're trying to put people in a difficult position.
Mhm.
Other possibility is that you take the Renters Reform Bill as was, chop out a couple of bits you don't like, and the obvious things that will be removed are any suggestion that the courts will be reformed first. The whole thing about tenants not being able to give notice inside the first 6 months, I don't see that making it. You chop out those bits you don't like, and you basically get the Renters Reform Bill back in for a rapid passing through Parliament, and potentially you even start it in the House of Lords because it's relatively uncontroversial. You run it through the Lords first, and then the Commons merely rubber stamps it, and everyone moves on quite quickly. So both of those options are plausible, and of course the advantage of doing the second one is that you get all the other stuff done as well, and you don't have to come back and do this again later. If you do a micro bill, the reality is that the Labour Party are going to want to come back and revisit all this in another year or so. And if you're reasonably happy with a lot of the other stuff, you might just push through the Renters Reform Bill as was, and um, that's not such a problem from the Labour perspective because the way it's been drafted, so much of the stuff was for regulations anyway. Um, it actually it actually meant that they had an enormous amount of latitude anyway, so you could actually push the Renters Reform Bill through relatively untouched and still preserve a great deal of latitude to do different things once you've had a chance to sort of think about it.
And do you think both those kind of options there you mentioned, so just a mini bill, if you like, of abolishing Section 21 and bolstering Section 8, or bringing back the Renters Reform Bill, both of which could be done pre-party conference recess, you think quite manageably?
I think you may not get the whole thing done pre-conference recess, but I think you'll get most of it done, and you polish it off before Christmas.
Okay.
And therefore you basically preserve your general position of we're getting it done.
Yep.
I mean, there's obviously a huge desire from the Labour Party to get quick wins, and one of the things that Rishi Sunak did intentionally or not, I do not know, was to queer the pitch in terms of the sort of first 100 days. You've always got this position from new governments. They get a bit of a honeymoon period for the first 100 days or so before people start to say, well, what are you doing?
Mm-hmm.
If you position someone's first 100 days across the summer, that's not normally a time when Parliament does a lot of stuff. Most of Parliament's business actually gets conducted in the spring and the early part of the year, from January through till about sort of April time, and then it starts to slowly slow down as you go through Easter, long summer recess, party conference, and then heading towards Christmas. You don't get vast amounts of done during those periods. So a lot of stuff tends to happen early in the year. So if you'd had the election in sort of October, November time, you would have gone straight to Christmas pretty much, and some bills would have got started, but then everyone had Christmas, and then the party would have come back, and a Labour government would have done loads and loads in sort of January, February, whereas now they've got to start scrambling around to adjust recesses and things that are generally quite, traditional within the parliamentary calendar. And then you've got to deal with other stuff. You've got to deal with a budget somewhere in all this. You've got to decide whether you're going to have a state opening of parliament or run a slightly long parliament, because normally they happen fairly routinely in sort of late October, early November. There's not much point in doing that. Again, having just had an opening of parliament in July. So do you run a long, so you'll probably run a long parliament through to November. And these are all things that people don't think about, but which actually are really important from timetabling perspective in terms of actually getting stuff done. In what in effect is just a very big office with more hoopla and TV, but it's still offices.
No, for sure. And you mentioned, so that, I guess that was at the big, you mentioned two key things.
Right. Well, the other big manifesto promise, which I thought was really interesting, was bringing Awab's law into the private rented sector. So Awab's law is named after a young boy called Awab Ishaq, who was killed, or died more accurately, in a social housing property from extreme ill health brought on by damp and mold growth in his property. And the social landlord had been, the best way to phrase this, dismissive, shall we say, of the tenants' complaints. I mean, grossly dismissive of the tenants' complaints. And the side effect of that is that there was a new piece of legislation called the Social Housing Regulation Act 2023, which came into force. Not all of it is yet in force, but one of the things that was in that was a power to pass regulations to require social landlords to act on a specific timetable in respect of damp and mold growth complaints, both in terms of inspection and resolution. The consultation to make those regulations closed shortly before the election was announced, so nothing has happened. It's, again, the Labour Party is likely to push those regulations through into the social housing sector quite quickly because it's a quick wins point, gets you something done. They're also obviously keen to bring it into the private rented sector. And I would anticipate, even in a quick bill, you would do something whereby the social housing Regulation Act, that particular section gets dragged across, and you say, well, this will also apply in the PRS for this definition of landlord, and then you make regulations as appropriate. You'll have to rerun a consultation, but you can see that something can be done relatively promptly because the legislation in effect is there, and you just rewrite it and you keep it quite limited. Obviously, this will have huge effects though for the sector and agents, and indeed people like Fixflo, for example, will really need to think about their process and procedure for dealing with damp and mold growth. And the problem with damp and mold growth is that people are often a bit quick to say this is tenant lifestyle. And yeah, sure, it often is tenant lifestyle, but it's not just tenant lifestyle. It also tends to link to how warm your property is, what the airflow is like in your property, how expensive it is to heat your property. Essentially, you don't get as much damp and mold growth problems in a property with a B rating for an EPC as you do in a D rating for an EPC, because tenants are more likely to have the heating on. So there are more fundamental issues around damp and mold growth that I think that the sector will need to address, and the chances are they're going to be forced to do so if Awab's law comes into the PRS. You've then also got side promises. So recently, both Keir Starmer and Angela Rayner made comments around agents bidding up tenants and encouraging them to bid, and saying that they'll get rid of rental bidding. And there's been a lot of reference to similar legislation in New Zealand, which basically says you must advertise the price of your property, and then you can't encourage tenants to bid up. If tenants choose to bid up, that's up to them, but you can't encourage them to do so. So what you can't do is say, well, I've had a lot of other offers and you really should bid over the asking to get this property. But the problem with that as a concept is that tenants will bid up without very much prompting anyway if they think that if there's a property they want. And of course, the other way to deal with it is you simply you bid down rather than bid up. So you set the asking price extremely high and invite offers in the region of the asking price, and you don't get people to bid up. You simply say, well, this was the asking price, and encourage people to and say need to make offers, and you get people to bid up to your price as opposed to trying to bid over your price. So you simply you shift the bar into a different place. So I'm not. And then the other problem with this legislation is enforceability. There's quite a lot of legislation, the PRS, that's unenforced because local authorities don't have the time and energy, but also just because it's really hard to enforce. And how are you going to enforce a piece of legislation where the tenant's saying, oh, the agent definitely encouraged me to bid above the price, and the agent saying, I didn't say anything at all. I simply said that there were lots of offers and they would have to make an attractive offer.
Yeah.
So the wording is really, it's really mealy mouthed as to, you can encourage people to bid up without ever actually encouraging them to bid up.
You make action.
You see what I mean? It's really easy to convey a meaning that suggests that bidding higher might be in your interest without actually doing it.
Of course. And I know you mentioned they were kind of modeling it off from something in New Zealand. How have they enforced it in reality? Have they been successful to or struggle?
I don't really know. I mean, I've read the legislation in New Zealand, but I don't have any on the ground information about how it works there, and certainly that's something that people might be worth looking at, and it may be that people have studied it. I don't know off the top of my head, I'm afraid. And then you've got other sort of things that the Labour Party have said that they want to do. For example, the Conservative Party U-turned on MEES. And said that they weren't going to bring it in, and the Labour Party made crystal clear that they would U-turn on that and do something on MEES. That doesn't require much doing because that's a matter of regulations. So I can see MEES being pushed back onto the sector. Again, the exact timelines, the standard that's required, whether you're going to immediately turn around and say everyone has to hit a C, or whether you're going to say, well, D by this date and C by this date, whether people will get exemptions if it's costing them more than X amount of money, £10,000, say, to meet a standard, or whether it's we don't care what it's costing you, just have to meet it. These are all possibilities. And then also there's a question of support. At the moment, it's all stick, and there's not a lot of carrot in this. And I don't know whether a totally different approach to the Treasury will help. And for example, one of the things that I've certainly suggested and called for in numerous different guises is that it doesn't make any sense that if my boiler is broken, I can replace it with a brand new air source heat pump and get that as a tax deduction because it's a repair. But if it's not broken, I simply want to make my property better, I can't get that as a tax deduction because it's not a repair. I think it's an extremely artificial and not terribly productive distinction. And I think the Treasury would do better to allow those to be more tax deductible, because I think in the end they would get the wins in other tax receipts across VAT and income tax off the installers and all the rest of it. So I think it's an area that's ripe for some gentle, not massive giveaway incentivization.
Okay, interesting. Then there was one.
So many different Labour Party things.
Yeah, no, it's fine. I guess the one thing that I know we had a question about was, and I'm not sure if you've done or seen much about it, was that there was kind of mention of a hardship test, and that from Section 8 possession grounds standpoint, that it could be up to the courts to decide whether, if they were said landlord was going to move a family member in, that it was if the tenant was to be they were deemed to win, in inverted commas, the hardship test, that the courts could intervene. There was a question about that previously.
No, I don't think that I'm not aware of any clear statement from Labour about that. I mean, this is where people get themselves completely off kilter. I think what actually that question might be referring to is there is a hardship test on rent increases within the Renters Reform Bill.
Okay.
I've heard it, people getting more and more weirdly excited about this, saying, and to be fair, I started this hair run myself, because what I did say is that one of the problems with this is that on the Renters Reform Bill, if a rent increase was being agreed by the tribunal, they were supposed to backdate it to the date of the increase unless it would cause exceptional hardship. And the point I made is that if there's a substantial rent increase and it's taken the tribunal 6 to 8 months to hear it, then that's a lot of money to ask a tenant to pay. And is that exceptional hardship? But again, you've got to bear in mind where you live. The UK jurisdiction, and I have people who constantly say, "Oh, this is terrible," but then at the same time will, in the next breath, will decry every other European country and say, why we don't want to be members of the EU? We're so glad we left. It's like, well, British law works by writing law in a general sense, and the courts fleshing out the details on a case-by-case basis. That is the nature of the British legal system. If you don't like that, then presumably what you actually want is the French legal system, and that has lots of disadvantages as well. So, the reality is that law is written in the UK in a relatively general sense, and most of these things will have to be worked out in the courts. I'm not overly worried about a hardship test. No.
Okay, brilliant. And there was just one more to stay on this topic. For remaining couple of minutes was just, I know one of the questions we got pre-webinar was, one of Labour's main pieces they said the PRS must hit minimum energy efficiency by 2030. Of course, this is only 5 and a bit years away. There wasn't much clarity around this and what they actually meant by this. I know you've kind of mentioned MEES there as already as part of that. Do you think that's the key point on the 2030 target piece?
But that's not what Labour said at all.
Well, there we go.
What Labour said is that they would reverse the government's decision not to make the sector hit it by 2030. They didn't. They weren't specific about a date, and I think they'd have to consider it. And I think they're probably keen to get there by 2030. But where is there in this context? I don't think it's terribly realistic for a Labour government to come in and say that the whole sector has to get to C. I think you also need to understand there's a gap between what the Labour Party says in opposition without the benefit of all the details, and what the Labour Party will actually say and do when they're sitting in government with loads of civil servants saying to them, guys, that's just not going to happen. And having to face the cold reality of governing. There's just a world of difference, and I think people underestimate the very significant difference between being in opposition and pretty much saying whatever the hell you like, frankly. I mean, this is, I suppose, is the criticism of I don't know, of Reform. I mean, Reform's got all kinds of wild promises in their manifesto, and Nigel Farage was asked about this, and he said, well, we're not really intending to govern with this stuff because we're not going to get elected. But this is our promise, and next time around we might. And it's like, well, I mean, one angle, and someone asked Ed Davey about this and said, well, what's the point of your manifesto? You're not going to be in power anyway, so say whatever you want. But the reality is parties have to set out a general scheme for government because that's what we expect of them. But manifesto promises are historically not kept. But the main reason for that is not because all politicians are liars. I mean, they may also be that too. But it's more because it's pretty easy to make promises in a manifesto. It's a hell of a lot harder to actually do it once you're there. And I think I'd be surprised if a Labour government was going to try and make the whole PRS hit C by 2030, because I completely agree with people who are saying that's just not possible. I don't think it is.
No. Okay. Very well. And I know the main question, of course, we got time and time again prior to the webinar even, is Labour going to ban Section 21 straight away? And I think hopefully we kind of answered that with those those two ways in which they would be able to get it through rather quickly, potentially.
Yeah, I think they'll get on with it, but immediately again as a manifesto statement, it's not. There is no power for the Labour Party to turn around on day one and say you cannot progress a Section 21. I mean, the real question you're really asking me is phasing and timing. Will served Section 21s continue to be able to be used as the Renters Reform Bill comes through? I can't tell you for sure because I don't write the legislation. I'm not implementing it. You won't even be able to tell as the Renters Reform Bill goes through Parliament because mostly that stuff's dealt with in regulations. All I can say to you is that I've never seen a party or a government, or it's very rare, more accurately, for a government to 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 act in a way that says that things that have been validly served, notices have been validly served today, are no longer valid as if by magic. It is normal for these things to be phased through. And I would be surprised if Labour wanted to do something that was wildly abnormal. That's just really not who Keir Starmer is, frankly. He's just not that guy. Sorry.
There we go. But I think we'll park that piece there for the moment, but please do kind of keep questions coming through, perhaps on other bits and pieces, and we'll address them as we go. David, legal updates. We always call this a quarterly legal update webinar. I know there's a couple of cases that have come across.
Did we do any law yet? I suddenly realised I'm sitting here as a lawyer, not talking about the law. I was talking about like putative future law that may not exist.
But I know there were a couple of cases that you thought would be worth mentioning today.
Yeah, there are quite a few. I mean, yeah, the world does continue outside the election. Other stuff does in fact happen. And there are quite a few interesting cases knocking around at the moment. So one of the ones that I think is quite apposite is there's been a recent decision in the county courts, I hasten to add, so it's not binding, but it's by a circuit judge, and it is important, about gas safety certificates. Again, always love a good gas safety certificate.
Love a gas safety cert.
So this is not about gas safety certs per se, but is actually more about a more unusual situation, which is where you have a boiler replaced during the tenancy. So the legislation requires that if you replace the boiler during the tenancy, you're required to give a tenant certification of that. In this case, the landlord simply didn't do it. His contractor didn't bother because, frankly, they were the cheapest contractor the landlord could have got their hands on. It is actually technically a legal requirement to have a building reg certification if you replace a boiler. This contractor simply didn't bother doing it. None was served on the tenant, and the landlord knew a GSC was coming up a couple of months later and simply got a GSC and served that and said that was good enough. The court did not agree and said that the building reg cert should have been done and served on the tenant. It wasn't something you could fix after the fact, and so no Section 21 could be served. So it's important to bear in mind, if you are going to get a boiler replaced or a gas appliance replaced during a tenancy, you must get the building reg certification done and you must serve it on the tenant. You can't hang off until some later date or assume you don't have to do it. The gas regulations are pretty clear. Not to put too fine a point in it.
No.
And then there's a sort of collection of cases popping up in the upper tribunal, high courts, and courts of appeal. So starting at the bottom of the train, there's a case about rent repayment orders popping up into the upper tribunal. And this specifically deals with last-minute rent repayment orders. Essentially, you've only got 12 months to make an application for a rent repayment order after the offence ceases to be committed. So if I didn't have an HMO license, my tenants can apply for a rent repayment order. If I then apply for an HMO license, then the offence ceases being committed, and then they have 12 months to make an application. There was a case where tenants left it basically to the last possible day, and therefore there is now a case before the upper tribunal on what was actually the last possible day. So if I apply on the 4th of May for my license, is the last possible day to apply for rent repayment order the 4th of May the following year? or is it actually the 3rd of May, or is it in fact the 5th of May? And the reason it's difficult to divine, because it would sound like to most people it's patently obvious, but it's not, because the way the legislation is written, it says the offence stops being committed on the day you apply for the license. So if I apply for a license at 3:30 in the afternoon, then I have stopped committing the offence backwards in time from midnight and a minute in one reading. Or alternatively, I actually stop committing the offence the following day. So it depends how you choose to read the wording of the legislation. There's a number of different interpretations. And obviously, if you're going to leave these things to the wire, then that precise day thing matters. And I'm sure most people think, well, what a bloody waste of time. But these are the kind of obvious stuff doesn't tend to go to court that much, and it certainly doesn't get appealed because it's obvious. And I often have people say to me, I say, oh, the legislation says this, and they say, well, what court decision supports that? And it's like, well, no court decision supports that because it's just so blindingly obvious. Frankly, no one's bothered arguing about it. But it's those boundary situations where appeal courts, of course, get really involved. The other area that's come back again to haunt us a bit is coming back again to haunt us is mental health moratoria. So there's actually been a decision just in the last couple of days on mental health moratorium where someone had applied for a bankruptcy order against an individual wrongly on the basis, and they shouldn't have applied for it. It shouldn't have been granted because that person had a mental health breathing space in place. But the court has a discretion to override a breathing space and make the bankruptcy order anyway. And essentially, that's exactly what happened. So the initial bankruptcy court, and then on appeal, the High Court said, well, got discretion. We think the mental health breathing space was a nonsense anyway, and it was obtained dishonestly. So we're just overriding the bankruptcy, overriding it, and we're still making this person bankrupt. And then there's also a case appearing before the High Court, which is an appeal from a circuit judge about breathing spaces and their application to mortgage cases. So there's quite a lot of clarity going through breathing spaces. And it's quite an important point because mental health breathing spaces are relatively easily acquired in that the medical profession is quite reluctant to put itself at risk by suggesting that someone shouldn't have a mental health breathing space, and they will tend to err on the side of saying that someone needs one to protect them from obviously suicide risk and things like that, because the medical profession doesn't want to be sued for not saying someone needs mental health protection and then they commit suicide and people come after them. So they're erring on the side of caution. The courts are saying, well, hang on a minute, you can't just let everybody off their debts, and there's got to be some degree of balance here, and there's a sort of tension there between two different professions, which is being worked through in the courts at the moment. Then moving up to the Courts of Appeal, there are several cases before the Courts of Appeal in different contexts running through the latter part of this year and into next year. One of them relates to my perennial favorite, tenancy deposit protection, and whether or not deposit PI needs to be signed. So after a case called Northwood Solihull versus Fearns, it was held that an agent and even an employee of an agent could simply sign a PI certificate on behalf of the landlord, as long as they were reasonably appointed to do so. In the case that's coming before the Court of Appeal called Charterhouse and Lowe, the deposit certificate isn't signed at all, but the covering letter that sent it was signed. And at first instance and on appeal, the courts kind of said, well, Northwood Solihull says that you don't have to have it signed, which it doesn't quite say. But all that's really required is someone turns their mind to the accuracy of the statement, and therefore, if the covering letter is signed, then that will do. So there's some degree of flexibility being applied, and this was almost always somewhat inevitable, I think, off the back of the Northwood Solihull decision, but that's going to end up back before the Court of Appeal to ascertain just how much flexibility exists in the system. I suspect not as much, but I'm biased because I'm arguing for the tenant on that particular one. So my
Well,
view is
including
that
that again. There we go.
yeah, so yeah, you may not want to cheer for me there. Then there are a couple of other interesting cases. There's a case called Dobiny and Khan that's coming before the Court of Appeal, which I'm intervening in, um, where the tenant is arguing that they weren't properly served with all of the deposit protection and gas safety certificates because and the how to rent guide. So the clause in the tenancy agreement merely says that notices can be served by first class post, and the tenant is saying that the how to rent guide isn't a notice, it's a document, and therefore it wasn't validly served on me. I don't think it's a particularly good argument, but it's going before the Court of Appeal for them to decide whether notice means, well, it should be given a wider meaning basically to include other reasonable stuff, or whether it should be given a very strict, narrow meaning. I'm pretty confident the Court of Appeal will go for a wider meaning, but again, obviously biased there because I'm intervening to argue that point for somebody. And then there's another case which I'm not intervening in. I was hoping to intervene in, but I haven't managed to get anyone to agree to do it. Which is to do with the Tenant Fees Act, actually, and deals with a situation where a checkout fee was taken pre-Tenant Fees Act, and the tenancy was then renewed, so the checkout fee has never been spent because there's never been a checkout. And it's being argued that Section 21 can't be served because there is an unlawful payment in place. Now, the way the Tenant Fees Act is worded, it says if you do a renewal, you basically can't apply the TFA to old tenancies. But there's another provision in the TFA which reads slightly differently. So which one is going to rule is the question, and that's something the Court of Appeal will have to deal with. Again, I don't think the tenant's argument is particularly strong on that, but we'll have to see. So, I mean, what's interesting about these cases is that two of them have to do with Section 21, and so they could be held to be somewhat academic, but they don't just relate to Section 21, they relate to other stuff too, like the proper way to serve the how to rent guide and gas safety certificates and deposit PI, which are likely to have effects for lots of other stuff. And so they have important points of principle in them that stretch beyond merely Section 21. It's just that Section 21 is the key, because tenants are being evicted and the landlord obviously wants to preserve their ability to use Section 21. So they're quite interesting cases, but we'll have to see how they all pan out. But you're going to have to hold your horses, I'm afraid. The first one of those isn't listed until October this year, and one of them's not listed to July next year. So no rush.
It's still under your phasing point from earlier. They will, no matter what happens, as I almost said when then, if a Labour government comes in, they could still be read and cases still go forward, despite if it's being phased.
Those cases will still be heard because they cover wider issues above and beyond Section 21. And yeah, I don't think the Labour Party will. It would be incredibly perverse for the Labour Party to turn around and say that extant cases that were before the courts should be set aside. The only time it's actually happened is that part of the fixing for the super strike mess in the Deregulation Act did in fact lead to deposit protection claims by tenants against landlords who hadn't reserved the PI when the tenancy was renewed or when it went stat periodic. Some of those cases were effectively knocked out partway through the court system, but there were very specific provisions to deal with that, and also to say that cost orders couldn't be made against tenants in those positions because even though they'd sort of instantly lost, and that was also to fix a pre-existing blunder in the legislation. So it is possible, I say, for things to be backdated, but it's very rare, and it's usually where there's been a cock up and it's being fixed. And I suppose you could call Section 21 a cock-up, but that's not really true, is it? It's very clearly not a cock-up. It was very clearly an intended structure within the legislation.
Perfect. Brilliant. Thank you for those. I guess the final, we've got lots of questions again, well, mainly around the Section 21 piece, but hopefully we've covered that in the two ways in which that could happen potentially quite quickly, and then the phasing out of it over time as well as mentioned. And then the other key piece kind of questions on AWAB's law, and that being brought in from the social housing sector and kind of brought across to the PRS as well. I'm just trying to think in terms of writing through these questions. Any other points we haven't missed? I don't think there are really. In terms of closing statements or sentiments, I know a few minutes early, David, but is there anything else you wanted to flag to the audience today that it's worth noting?
I think you're just going to have to wait now. It's what's it, a week on Thursday. You'll know who's in charge, and it'll take a few days for things to settle out. But I think the real thing to look at is on or after July 7th, which is the opening of the state opening Parliament. I think the King's speech at the new opening of Parliament on July 7th will give you a much clearer picture of what is immediately intended, and that's when things will really kick into high gear, and lobbyists will be out there lobbying hard to make sure that that their points come across.
Great stuff. And that leads me to think that when we jump on this in a few months' time, we'll have a lot more, a fair bit more certainty around. Of course, we'll know who's in power for one, but also, yeah, know what the kind of next few months, years will entail.
Yeah, a legal update in August or September will be a much busier discussion.
There we go. And as a final note, we look forward to that. But David, thank you as always for your time. We always massively appreciate it. And I will come up with another superlative to describe you. I've got 3 months to do it. So there we go.
No pressure. Thank you very much.
Great stuff. Cheers, David. Thanks.